Board Member Ransom. Here. Board Member Mears.
Here.
Board Member Field.
Here.
Vice Chair Vincent.
Here.
Chair Golick.
Here. Okay, the procedure. For each matter considered by the board, there will be a staff presentation followed by a presentation from the project applicant, then discussion by the board. Both staff and the applicants will have the right for a rebuttal presentation prior to closing the public hearing. Public comments on all matters on the agenda shall be taken during agenda item 6. All public testimony will be limited to 3 minutes per person. All public testimony must be presented to the board at the podium. The 3 lights on the podium next to the microphone will indicate the amount of time remaining for the speaker. The green light will be turned on when the speaker begins. The yellow light will come on with a soft bell ring when 1 minute is remaining. The speaker should be completing the testimony by the time the red light comes on, with a final bell indicating the time has expired. Any testimony that references race, religious ethnicity, economic status, national origins, or any other classification protected under the state and federal law is a derogatory manner and shall be deemed irrelevant and will not be considered by the board in making its determinations. In accordance with Section 11 of Article 2, the appellant and the department will have each 10 minutes to present their position. The department shall present first, then the appellant will present. Each party will have 3 minutes for rebuttal. After the rebuttal, board members may ask questions of either party, and the board will then close the hearing and discuss the appeal and deliberate on the appropriate action. Now we'll proceed with the approval of the agenda.
Excuse me, can I get a copy of the agenda, please? I didn't get one.
Madam Chair, I'd move to approve the agenda.
Procedurally, first, let's confirm there are no changes to the agenda. This is Ashley Atkinson, Assistant Director for Planning and Development, sitting in for Eric Frampton as building official since he is out today. There are no changes proposed to the agenda by staff.
Okay. And board members, are there any changes on your part to the agenda? Is there a motion to approve as amended?
I have a motion to approve.
Second.
All in favor?
Aye.
Aye.
Aye. Okay. So, let's see here. So let's move on. The agenda is approved. We will now move on to the consent calendar. On the consent calendars, we have 4A, approval of the February 3rd Building Standards meeting minutes, and approval of February 17 Building Standard regular meeting. Is there a motion to approve the consent calendar?
Move to approve both minutes as presented.
Second?
Second.
All in favor?
Aye.
Opposed? The consent calendar is approved, and we will move on to the reports by the board members. Board members, do you wish to make any reports?
No, nothing.
None? Okay, we will move on to public comment. We are now going to take public comments on all matters. Would any member of the public, would you like to speak on items on continued or new matters? If so, each speaker has 3 minutes. Please identify the item that you will comment and begin your comments. No? Okay, none. So we'll move on to continued matters. There are no items in continued matters, so we will now move on to new matters. Okay, let's go on to new matters. So I will let, the hearing will be held as follows. So we have staff presenting. This is the hearings to determine whether good cause exists to accept the late appeal filing for 1347 East Shields Avenue. Anybody wants to do a presentation?
Good afternoon. So my name is Marie Chalet Porter, and I live here in Fresno, and I work in San Francisco as a registered nurse. I am appealing for a good cause on the fact that initially the letter was sent to an incorrect address and had to be rerouted to me, which took an additional amount of time to get to my home. Aside from that, when I did receive the letter, it was after I was in San Francisco working. And also I traveled for business in January, in the beginning of January. So I was not in town until January 28th of this year, 2026, which is when I received and submitted the appeal. But unfortunately, it was after the 15 days that was allotted for me to be able to submit the appeal. For that reason, I am asking for good cause to be able to submit my appeal and get my case heard.
Okay. So you're asking for an extended time?
Yes.
Okay. Board members, do you have any questions?
Not of the appellant at this time. I do have some questions about this for staff.
Thank you. Okay.
Okay.
We'll-
So no
we'll-
questions?
Yeah.
Okay. Thank you.
Okay.
So can we get a clarification from staff? The way that the actions are listed on the agenda for us to do, I was taking this as just making a judgment on the appeal or the late filing of the appeal notice or request and not into the violations that are included because, for example, item 2.3 says dismiss the first administrative citation. So that kind of confused me and I'd like clarification on that.
I think I can speak briefly on that. Christina Roberson, Assistant City Attorney. Good afternoon. I think that is for the second hearing. There is a hearing today regarding the property on Fillmore, which is an actual hearing for the appeal. This first hearing is just to determine whether good cause exists to accept the late appeal.
Okay, you're correct. I mistook that.
No problem. Thank you.
Thank you. Okay, shall I will close it now and I will have the board members, we'll have a discussion. This is closed right now for discussion amongst the board members.
I think the extensions should be granted just because she's given proof of that she was here when the citation came and it was sent to the wrong address. So I don't have a problem giving the extension.
I agree. You know, but compounding things.
Do you all, anybody has any other ideas?
No.
She has some excellent points. Traveling nurse, number one, and being delivered to the wrong address initially.
Yeah, I agree. I tend to agree. So let's begin a motion to deny or accept the late appeal. So who would like to make a motion to accept the appeal?
Motion to accept?
Second.
All right. All in favor?
Aye.
Aye. Okay, opposed? No, none, so we're good.
So please work with city staff to figure out what's going. I started reading some of the things in your appeal. Sounds like there's question as to what was supposed to apply here. Continue working with staff, and it may avoid some of the citations coming. So, thank you.
Thank you. All right, so let's go on to item 8B. And may I have the staff begin the presentation?
Good afternoon. Let me get this. Testing. All right. So good afternoon, board members. We are here today about a citation, the first administrative citation that was issued to 4816 East Fillmore. At the end of today's hearing, you have three options. You can confirm that citation in its entirety, you can confirm part of it and dismiss part of it, or you could dismiss it in its entirety. And the city recommends that you confirm the citation in its entirety. So this is a fairly substantial case. We're going to look just at the parts that are pertinent to the citation that was issued today, issued in December. So this case was opened at the end of February in 2023. At the end of January 2025, Inspector Brad Morgan, the current inspector, was then assigned to the case. He conducted an inspection in the middle of August 2025, and after that inspection, conducted an inquiry into city permits. Based on what he found there, he issued a notice and order on the 29th of August with 5 different violations, which we'll get into a little further in a moment. That had a deadline of September 16th. At the time of that deadline, he granted an extension and in fact ended up granting a second extension at the beginning of October, which took us through to the beginning of December. Towards the beginning of December, he conducted a reinspection of the property, did another check of city records for permits. He found that a new permit information had been submitted for it, but it had not yet been issued because there was a balance due that had not yet been paid. Other than that, there were no changes at that time. So based on the length of time since that notice and order was issued, we were at about 4 months later, Inspector Morgan issued a first administrative citation for those same 5 violations that were in the notice and order. So the scope of today's hearing, it is limited to that citation, which is what was appealed, and the grounds for relief that were raised by the appellant. And you can see an excerpt from page 134 of the appeal packet. The grounds that the appellant raised was that the city was requesting a CFRI, and they were working on those forms. So in order to confirm the citation, you as the board members must be satisfied by a preponderance of the evidence that the violations of the FMC existed at the property, that after the notice deadline passed, they remained, and that proper notice was served on the property owner. Now, I'm sure we're all familiar with the criminal court standard beyond a reasonable doubt. That is a different standard of proof than what we do in administrative hearings. When we're talking about preponderance of the evidence, we're talking about, is it more likely than not? If we're putting that in numbers, if something is 51% likely to be true, that means the burden has been met and the fact should go in the city's favor. Now, going into a detailed look at each of the 5 violations, the first 3 are very, very similar. Violation 1 is that on one of the buildings, there were multiple HVAC units that had been replaced without permits and inspections. We list out the Fresno Municipal Code and California Mechanical Code sections that it's a violation of to have those changed out without the permits and inspections. And Inspector Morgan observed that they were new units and searched city permit records and found that there were no permits that had been finalized for this. And Inspector Morgan has observed that this violation currently remains uncorrected as well. You can see this is a photograph from the notice and order that shows those 2 new units on the building, and during the time of the citation, early December, those same 2 units. Violation number 2 is virtually identical, except we're now talking about a different building. HVAC permits are done on a per building basis, which is why there are 3 different violations. So this is a separate building. Other than that, identical facts. Again, we have photographs from the notice and order and the citation of that other building showing some of the new units. Violation 3, third building, same issue, HVACs replaced without permits and without inspections finalizing those permits. Other than that, the sections that are violated by it and Inspector Morgan's date and time of observations, substantively identical. And we have photographs from the time of the notice and order and the citation for that third building. Violation number 4, there were 2 permits that had expired at the time of Inspector Morgan's notice and order. One of them was for building and electrical work that had been done on the carport. That permit had been pulled in 2023, but was abandoned after 180 days with no work done. So at the time of the notice and order, and then again at the time of the citation, no new permits had been done to do that, and nothing had been done to taken these out of the abandoned status and seen through to completion. You can also see a printout with information on that particular permit starting on page 71 of the appeal packet. And we have violation 5, which was for one HVAC unit on apartment 102 for the replacement of it. It was pulled at the same, around the same time in 2023, again, abandoned after 180 days with no action taken on it. We, again, list the sections that it's in violation of and list Inspector Morgan's observations and what he found on the city permit searches that indicated repeatedly no action taken to either see those through to completion or get them replaced. And you can see starting on page 86 of the city's appeal packet is information on that particular permit. So after that deadline passed for the notice and order, which was September 16th, the violations remained. Inspector Morgan, as a courtesy, ended up giving 2 different extensions, which is what saw us through to the beginning of December. At that time, still nothing had happened. So at that point, Inspector Morgan did issue the citation. Proper notice of the notice and order was served on the property owner. It was mailed, not only first class and certified mail, you'll see the proofs of service in the packet, it was also posted at the property, and it contained all of the information that the Fresno Municipal Code requires that we include. The citation as well, sent out on December 17th. It was mailed first class and certified. You can see the proofs of service in the packet, and it contained all of the information a citation is required to contain. Appellants cited that they were working on a CFRI form as their grounds for relief. We cannot determine what they meant by that. There's no mention of a CFRI in the city permit records. So it looks like this would be an affirmative defense, which is something that the appellants assert that, if true, would override the fact that the city has met their burden of proof, met their case. So, as I mentioned earlier, we have the burden of proof to prove by preponderance of the evidence that these violations were present, were uncorrected. So with an affirmative defense, if we do that, it then shifts to the appellants to show extenuating circumstances or the relief that they're seeking that would override that. As previously stated, we do recommend that the board confirm that first administrative citation. Additionally, just some further background information, if the board finds that the violations are currently still uncorrected, that would trigger a progress hearing, which would be set for 30 to 60 days out. And as you see in the packets, to kind of help break down the decisions that you'll be looking to make today, we've included a findings matrix. It is at your discretion, absolutely, to use it as a resource or to discard it in totality. It's just there if it is something that you find useful as you go about making your decisions for these 5 violations. So that is the end of my presentation. Thank you so much.
Thank you. Do I have the appellant presentation?
Good afternoon. My name is Michael Titus. I'm an attorney with the law firm of Wild, Carter, and Tipton. I'm here on behalf of the appellates, the ownership group of this property on Fillmore Avenue. I have a few notes. I apologize. I'm trying to get them all organized here today. I believe the city staff is going to agree, just as an introductory standpoint, is that just because a notice and order is issued or just because a notice of in violation is issued doesn't automatically mean that a citation is issued. That ownership group or that property management group has the right to go ahead and cure those defects. And during that, or those alleged defects, and during the time frame of trying to correct those items, work with whether it's the code enforcement officer, the building department, things occur that are beyond that ownership group's control in meeting the deadline that is met, or a deadline that is set by a code enforcement officer who may not exactly work in the building department know what exactly is going on from behind the scenes. Now, I know the staff in their presentation talked a little bit about this case being opened up in 2023, but I believe it's important to kind of give a little bit of a historical background on this property. This property was subject to a prior appeal and administrative hearing that was heard by independent hearing officer Michael Flores on February 9th of 2026 this year. And from this hearing, I just want the panel here to be aware, or the board here to be aware that when it comes to inspections that take place on a premises, Fresno Municipal Code Section 1-303 states that when an inspection on a premise is necessary, that code enforcement officer has to obtain consent from the property's ownership group, its authorized agent, or a tenant of the property. Now, again, this is all for a historical background purpose, just to how we got here today. This matter was previously assigned to Luis Castellanos, who was a code enforcement officer back in 2023, and he conducted several inspections, none of them which had the required consent, which is all within the hearing packet. You can see that there's no consent that was applied for. Some of those inspections occurred on April 17, 23, August 29, 23, September 18, 23, December 6, 23, January 12th of 2024, February 2nd of 2024, May 21st of 2024, and August 29th of 2004. And we believe that what was found during those unlawful inspections by Mr. Castellanos is what led to an initial citation that was issued in September 5th of 2024. As I mentioned, the appeal on that citation took place in February of this year. And during that appeal, Mr. Morgan was the lone witness for the city who he had kind of stepped in the shoes and he had been reassigned this property on Fillmore. Now, I do want to mention that that citation was dismissed, and for reasons that we're not quite entirely sure of, but we believe that the city agreed that maybe that unlawful inspection did take place and the citation was dismissed. We believe that there was some documentation that was issued during that hearing that we believed we were entitled to. The city did not produce it. Regardless of that, the city attorney's office communicated to us that anything happened prior throughout 2023 and the notice and order that was issued in regards to today's hearing was not relevant. Therefore, we respectfully request that even though the city may have said that this case was opened in 2023, we'd like to focus on the fact of what occurred from the notice, and we'd like to kind of take the city's word for it and stick to the notice and order that was issued in 2024 and have this matter, or I'm sorry, have this matter kind of considered to the notice and order that was issued here today that's the subject to the citation. I may have the wrong date there. I believe it was 2025. My apologies. Now, as to as to the current appeal here today, on August 13th of 2025, Inspector Morgan conducted his inspection of this premises. Again, there are no notes about consent being taken place for that inspection in August of 2025, and we believe that's what led to the issuance of that notice. So again, we believe the consent issue is very big. Mr. Morgan could have reached out to the ownership group to conduct his inspection. That did not take place. Now, on page 31 of the case history report, I apologize. I don't have a Bates stamp copy, but on page 31 of the case history report, you can see that after the appellates were issued that notice and order, they actively worked for the acquisition of the permits. They went even as far to communicate to Mr. Morgan that they were making every effort necessary to complete the work as prompt as they could. And again, subsequent inspection occurred by Mr. Morgan. We believe this occurred without consent. This seems to be kind of a pattern with the city in this matter. And again, he conducted a inspection on December 5th of 2025. Again, we believe that was without consent. Now, as to the delays that this ownership group has suffered from, I have a declaration from the ownership group that I have copies of. I can pass it out to staff. I'll read it into the record. But this ownership ran into delays beyond their control, obtaining the necessary permits because they needed to do a HERS inspection. And I'm sure all of you are aware what a HERS inspection may be, but for those that don't know, it's an inspection that looks at all of the ducting within the unit to ensure that there's no leak, and it has to obtain a certain rating. And these are inspections that are done by a third party, not this appellate group. So they're kind of at the mercy of the scheduling of that third party group. Now, the company which attempted to complete the HERS inspection ran into issues because the application, I believe, that they submitted to the city was denied. The city wanted some additional information, and that is in the process of being scheduled within the near future here, I believe, and having that inspection done to get this work wrapped up. So as to the carport, there was an issue in regards to, let's start with the electrical of the carport. The ownership group attempted to work to get the electrical permitted, have it done, and get that finalized with the city. However, the city was requiring plans, and I know that the city staff is aware of this. Plans come, again, from a third-party architect, and they take well over 6 months to obtain for my clients because they have many properties in the city of Fresno. And in this case, they decided to abandon the electrical. They said it's going to take too long, and they wanted to remove the electrical. It just said, forget it, we'll just move on from that point. Well, when it came to the removal, the city came to them and said, you can't just remove the electrical, you need to submit some plans to have the electrical removed. There was a lot of back and forth with the city. Eventually, it was determined that plans were not necessary for the removal of the electrical, and that, I believe, has been taken care of. As to the other items regarding the carport, the permits have been applied for. There was a lot of back and forth with the building and planning department on that, and those were applied for, I believe, within the last week or two, so that item should be corrected. I'd like to read into the record here, and I have copies for everybody. I'll leave them up here. A declaration of Bryce Hovnesian. He's the authorized agent for the appellates in this case. It's short. It's not too long. It says, I, Bryce Hovnesian, declare as follows. I am the authorized agent for appellates JCH Family Limited Partnership, DBH Family Limited Partnership, and JAZ Family Limited Partnership. The premises located on 4186 East Fillmore Avenue is private property owned by appellates and is rented out to third-party tenants. Upon receipt of the notice and order dated August 29, 2025, appellates began to work diligently to correct any alleged violations within the notice. It should be noted that the original deadline, September 16, 2025, and any extensions to it could not be complied with due to reasons beyond appellate's control, including but not limited to a HERS inspection being required by the city, telling appellates, and the city telling appellates that plans were required as it pertains to the carport on the premises. Due to needing additional time, I instructed the premises' property management company to inform Inspector Morgan that appellates were actively working on obtaining the necessary permits and making every effort to complete the necessary work. Throughout the ensuing weeks, appellates began working with a third-party company to complete the required HERS inspection. It is my understanding that this third party had difficulties in scheduling its HERS inspection because the city of Fresno was requiring information be included within its application. As of the carport, the city of Fresno required that appellates submit plans for the removal of any electrical that was installed on the premises' carport. Appellants do not have the ability to draft their own plans and engage the services of a third-party architect to draft plans. Due to appellants believing that plans were not necessary for the removal of electrical, discussions ensued with the City of Fresno's Building and Planning Department. Ultimately, it was determined that plans were not required for the removal of the electrical. As to the other items regarding the carport, permits have been applied for. As the date of this declaration, appellants are still working to have its HERS inspection scheduled. I have one tiny paragraph here, with the third party so permits can be obtained. As communicated to the inspector, appellants are doing everything they can to diligently complete the work to the extent of what they can control. Appellants have the belief that so long as progress was continuing to be made as to the items within the notice, a citation would not be issued. I declare under penalty of perjury, under the laws of the state of California, that the foregoing is true and correct, executed on April 7th, 2026 at Fresno, California. Bryce Hovnesian. Again, we're just simply requesting that. I know there was the matrix that we saw there, and this group wants to complete this work. They just need time because this is items that they cannot control at this point, and they would respectfully request, if anything, that the citation, if anything, be dismissed, or we continue this to a later date to where we can do this work and this necessary work can be completed. Thank you for the consideration.
Thank you. Staff rebuttal.
Sorry.
Staff.
All right, so just to give some more information on some of the things that were presented. So everything prior to Inspector Morgan's assignment on this case is pretty irrelevant at this point. And honestly, because of the length of time in this case, that is to the benefit of the appellant, because the length of time in this case shows how long appellant has had to take care of these issues and did not do so. The HERS inspection that was mentioned is something that is supposed to be done promptly after the installation, before the building permit can be closed. So it should have been done in 2023 when these units were replaced. Now, I know something was mentioned as to every effort was made to communicate with Inspector Morgan. The city has no record of these efforts to communicate. There was a lone email, you'll see it in the case history report. There was a lone email in mid-September, which was a request for an extension, which was granted. There was no other substantive information, anything about difficulties that were faced or steps that had been taken. We have no record of that ever being communicated to us. And it looks like appellant did not bring any information to corroborate that today as well. All of the violations that are on this citation, additionally, they're visible from the public right away. The HVACs are right there on top of the building. You can see them from right there on the street. And with that, we ask that the board confirm the citation in totality. No continuance is needed. We recognize that the work is not yet complete, more time is needed, and that is exactly what the progress hearing procedure is for, so that the board makes a ruling on what the status was at the time that the citation was issued in December, but we set that progress hearing so that they have time without incurring further penalties to see that work to completion. So there is a perfect mechanism for that already in the Fresno Municipal Code. There's no need to continue. Thank you.
Just to confirm
Yes.
one thing. So permits were issued in 2023.
2 permits were, not for all of the HVACs. A permit for HVACs on one of the buildings was, and those 2, yes, they were applied for in 2023, abandoned after 6 months of no action.
Very good. Thank you.
Thank you.
Appellant,
yes.
rebuttal? Oh, pardon. Sorry. Thank you. Appellant, do you have a rebuttal?
Just very briefly, I want to note out that the notice and order itself says to communicate with the Building and Safety Department to determine whether there's permits or plans necessary. And I think that that is what directed, I know that there's they're calling it the loan communication, but there was communication to Mr. Morgan saying that they needed more time. They were working diligently. There were communications with the building department, as it stated on the notice. I mean, I don't know if Mr. Morgan, it appears that he didn't speak with the building department, even though he directed them per the notice to speak with them. That's the only thing I can comment on at that point. So, yeah.
Thank you.
Thank you.
Do I have any board members asking for questions? Any questions?
I do have a question for at the end there, or perhaps city attorney. I worked for a building department, and I don't recall building inspectors went on properties just as a part of their daily inspections. Is it required that the appellant give permission for a building inspector to come on their property when they are under construction of something that may or may not be in violation of the building code?
I would defer to the city attorneys to answer that question in the case of their inspectors.
Christina Roberson again. I will say that there is a difference of opinion between appellant's counsel and our office as to the interpretation of some of the codes. No, a building official, I think speaking just for building inspectors, technically a building inspector was probably invited there for an inspection, which means they have consent from the property owner to be there. However, our code enforcement's interpretation of our code is that in order to enter into a unit, we would need permission from the tenant, who is the one who has actual possession of the unit, but common areas where the mailman can go, the pizza delivery person can go, those areas would be open to anyone, including code enforcement officers. However, again, as Ms. Papazian stated, it's not very relevant in this case because those violations are visible from public right-of-way from the street.
Thank you.
Thank you. Any more questions?
So, just for point of clarification, am I to understand that no permits were required at all for installation of the HVAC systems? Because that's not what I'm hearing.
So in 2023, one permit was pulled that referenced Unit 102, and no other units on that building or any other buildings were referenced in it. I will say that we discovered at the end of March, so a week or so ago, 15 permits were applied for. But prior to that action, last week or the week before, the only HVAC was that one from 2023, and it only referenced for Unit 102 on it. Thank you.
Any more questions?
Well, I'll just, since I'm in the business, most of my clients, I would tell them they need an electrical permit. You need a mechanical permit because you're putting the unit on. Probably need a plumbing unit for the
Yes.
water that comes
Yes.
off the condensate to be able to dispose of it correctly. So there should probably be 3 permits required for each of those installations.
And I agree with you on that regards. Then, any more questions that we have? Shall we close this and have a discussion amongst us?
Good.
I'll close it and we're going to have a discussion. Anybody wants to discuss further?
I look at this and, the fact that they applied for the first permit in 2023 shows an obvious knowledge of the need for a permit. I think the filing of a bunch of permits a few weeks before this hearing is another kind of backdoor effort. I know that hers are required, and on our projects that we have going, we don't have the kind of time frames. Hers are usually, you're able to get someone out within a week or two. Plans for a carport, it's a pretty basic structure. I mean, unless this is a really elaborate carport, I have a little difficulty with that. And one of the questions that I had as I was listening to things was answered by the city staff in that the units are clearly visible from the street. I don't know that it's our place to get into consent of coming on property for an inspection, but if it's clearly visible from the public right of way, I'd kind of make that a non-issue.
I put that right there with people getting citations for roof replacement, and that's the same thing. They just drive by and see that the roof was replaced, and they get a citation for not getting the permit to do it.
Agreed. And most of the mechanical subcontractors, HVAC subcontractors, know about the HERS ratings and the need for a permit and those types of things.
I haven't heard that there was actually a licensed contractor doing this work.
And that we don't know. And I don't see, there seems to be a lack of correspondence and those types of things going on. So for me, that raises a lot of issues. I mean, our quibbling over the 23rd, even when it started in September, this is a long time to not have permits.
Especially mechanical.
Especially when it's a simple, it seems like it's a change out of a rooftop mounted unit.
Yeah.
That's about as simple as you get. And so we're not doing structural calculations to justify it because we're doing a unit replacement. We are reconnecting power and those types of things. It's 220 volt power, so it requires a permit. It's all of those kinds of things. You're right about the condensate. There's Title 24 documentation, and we've actually now gone to the point we just changed codes January 1st. So what could have been done in September is now something different.
Right. Because those new units probably don't.
Well,
And it's because of it doesn't appear that the ownership made a substantial effort in trying to get it done.
we're here just basically, I want you to remember that we're here to confirm certain premises. We have number one, the first one. You have to confirm the administrative code since December 15, as it is. The second one, you need to take out certain violations. So, and the third one is to dismiss it completely. And I want to hear from this discussion what you're leaning towards as far as for us accepting, do we want to go with 1, 2, or 3? This is what we're here for. So I need to get your opinions on what you're leaning towards and make a motion.
I would go with number one, the current for all.
Okay. Do we have somebody that would like to second it?
I will second that.
Okay, all in favor?
Aye.
Aye. Against? None. So we are going with number one.
Yes.
Yeah. That's it.
Thank you.
Thank you. So now, we would like to hear the report to the next item. The secretary, we need a report from the secretary, please. Do you have a report?
Sorry, that we do have one more item, which is 8C, a workshop on the burden of proof and preponderance of evidence. So before we move on to Secretary's report, let's do that.
Sorry about that, I
It's okay.
didn't see that. The workshop, burden of proof and evidence. So this is sponsored by the Development Department. So, okay. Let's hear about this
Yes,
burden of proof.
we do have the PowerPoint for this loaded, correct, Carrie? Daniel Casas from the City Attorney's Office will be presenting this workshop to share a little bit more in-depth guidance than what you heard during the last item about how to establish the required burden of proof to make your decisions.
How do I get it on full screen? Okay. Yeah. Good afternoon, Board. I was requested to prepare a short overview of what is a preponderance of the evidence for a little clearer understanding, given that sometimes we get confused with all the different standards of proof, the beyond a reasonable doubt, the clear and convincing, and the preponderance, which is the lowest standard of proof required for these type of appeals before this Board. So with that in mind, okay, well, I got to be smarter than technology. Oh, turn it around. Okay. The goal is to provide the Building Standards Appeals Board with an explanation of its responsibilities and obligations in an appeal before the Board, and explain the burden of proof required in matters before the Board, and which party has the burden of proof in a matter before the Board. The hearing procedures applicable to the hearing before this Board, the standard of proof that is applied, and the entities responsible for establishing the burden of proof. What happened? And the goal is to assist the Board in understanding their obligation when deciding an appeal and the standard of proof required in matters before the Board. The Building Standard Appeals Board is obligated to hear and decide appeals of orders, decisions, determinations made by the building official and or the code enforcement department that relates to violations in the housing regulations set forth in Chapter 11, Article 3 of the FMC, and the dangerous building ordinance set forth in Chapter 11, Article 4 of the FMC. Per the FMC 11-504, the Board must conduct its hearing in accordance with the general administrative hearing procedures set forth in Chapter 1, Article 4 of the FMC, which governs the general administrative procedures of administrative officers and hearing officers. FMC 11-504B states that the Building Standards Appeal Board does not have the authority to interpret the administrative provisions of the code or the power to weigh the requirements. Essentially what that means is that if the building code or the codes applicable to the hearings before this Board, if they state that A, B, C must be complied with, the Board does not have the discretion to say, I want A, B, but I'm going to ignore C. Or I have the ability to dismiss C and just adopt A and B. We are obligated to comply with the requirements of the FMC and the building codes. The administrative appeals hearing, the building official, officer, or employee who issues the order, citation, decision, or determination, or his or her designee has the obligation to present the evidence to support its finding or reasons for which the order, citation, decision, or determination was based. As was demonstrated today, the code enforcement had the obligation, they issued the citation, they issued they issued a citation in this case, so they have the burden to prove that the violation did occur when it occurred and that it's not been fixed. The building official, officer, employee who issued the order, citation, decision, or determination, or his or her designee is obligated to establish his or her position by a preponderance of the evidence, and that's set forth in the FMC, the general hearing procedures. The preponderance of the evidence has been a long-established principle that has been reinforced by the California Supreme Court and the California appellate courts. They repeatedly refer to the preponderance of the evidence as The preponderance of the evidence standard is the lowest standard of proof and simply requires the trier of fact to believe that the existence of a fact is probably or likely to be true, more probable or more likely to be true than not. As explained by the Judicial Council jury instructions, the party who has the burden of proof, either on a defense or on the presentation of the case, must persuade you by the evidence presented before the board that that what they are required to prove is more likely to be true than not. After weighing all the evidence presented by the parties, you cannot decide that something is more likely to be true or not true. Then you must conclude that the party did not carry its burden to persuade that a violation is more likely to have occurred than not. Preponderance of the evidence is a legal standard that requires a party to prove that their claim is more likely to be true than not, effectively demonstrating that a greater than 50% likelihood to be true based on the evidence presented. Like I said, there is 3 different types of standards of proof that courts uses. The most serious or more stringent one is the beyond a reasonable doubt. And you'll hear attorneys argue that it has to be 100% absence of any reasonable doubt based on the evidence presented. And that's a really hard standard because the person's liberty is mostly at stake there. The next standard below that is clear and convincing. And a lot of times, a lot of courts refer to that as more than 75% likely to be true. It's more highly persuasive that it is likely to be true, not likely to be true, that it's probably true by at least a majority, a substantial portion of the evidence. And then the lowest standard is preponderance of the evidence. And as examples, I'd have 3 illustrations. Here's the scales of justice. And this is supposed to illustrate that the scales of justice are even. And if after hearing all the evidence, the board cannot decide, and they say in their mind the scales have not tipped one way or the other, you must rule against the person who had the burden of proof. If it's the city, you must rule against the city. If it's the appellant, you must rule against the appellant. If it's a tie, it goes. The person who has the burden did not prove their case. Another illustration that is sometimes utilized in court is that when the evidence tips the scales, however slightly, in favor of a party, then that party has established its claim or defense by a preponderance of the evidence. And in this illustration, it shows a feather just tipping the scales, however slightly. It's more likely to be true, and you're of the opinion that it's more likely to be true than not, then the person has carried their burdens by preponderance of an evidence. And as discussed by the last case, and it's usually an example they use, that if you see, another example, that if you see the scales and it's 49 to 51, 51% is really tipping the scale for a preponderance of the evidence standard. And with that simple explanation, any questions?
It was very clear.
Yes, we appreciate your presentation.
Let
Thank
me
you.
ask one quick question. As we just evidenced, when someone comes in and starts talking about consent to go on property and that type of thing, is that information we should actually be considering?
It depends on the nature of the consent, because clearly even the FMC does not negate the constitutional right of the Fourth Amendment. The Fourth Amendment protects a person, their property is their castle. But there's a lot of exceptions to the Fourth Amendment. If you can see it from the streets, there's no consent needed. If it's open to the public and you can walk by and see it, no consent is needed. But if you start walking into somebody's door or a gated piece of property that's locked and you climb the fence, then you're getting closer to, are you violating the Fourth Amendment? If you start invading a person's privacy by opening a door without their permission, walking into an apartment or house or building, then that's a violation of the Fourth Amendment, and the Fourth Amendment supersedes the FMC, and you cannot violate the Fourth Amendment, even though some of the FMC say you have a right to entry and have you have a right to enter for an inspection, but you always have that caveat with the consent of the property owner, and that is intruding something that's protected by the Fourth Amendment that would allow that you need consent versus seeing something that is open, obvious, notorious, and visible from the public domain.
Now, there might be a point where it's not clear whether you are the property owner or the tenant. So how do you gauge, does the tenant have the right to not allow anyone to come in, even though the owner allows it?
Well, if the owner, see, that's between the owner and the tenant,
Yeah.
because essentially the tenant does have their own property, and their own personal privacy interests, and not allowing anybody in there unless they have the lease agreement allows the landlord to say, I have a right to entry, to do fixes, to do inspections, do the other things, and I have a right to delegate that interest or that authority over to a third party. But I don't think we'll see too many of those cases. If we do, then that's a bridge we can cross when we get there, because each set of facts may have a different outcome as to what is considered an open door. For example, if an inspector is walking by because of a barking dog, and all of a sudden they open a doors wide open, and they see some huge violation, that's not an invasion of privacy because it's visible from a public area, and they happen to see something that's open in plain view, versus walking into the apartment itself.
So in Chapter 1 of the California Building Code, it does state that there is, the building authority has a right to inspect for permitted work. So we've got a little tweak here today where a permit had been issued in 23 but then expired. Does that give a right to inspect or view the work that was permitted but allowed to go expired?
Well, I think that the facts, as I understood them, that were presented today, was that the person who for lack of a better word, did the inspection, did it from a public easement, and they were able to look up and say, hey, there's a brand new HVAC on the roof. Let me check to see if there's any permits pulled.
Yes.
And so they checked to see if any permits were pulled, and that is not a violation. It's different if they climbed on the roof.
Yeah.
And you're getting a little closer to that Fourth Amendment. But in this case, everything that I heard was essentially that everything was viewed from a public easement, and there was open and obvious, and there's a matter of then going back to the office, checking to see if a permit was ever obtained, and then that's the whatever evidence presented to the board, you base your decision on that.
Okay,
Very good.
thank you.
I have a question.
Yes.
Getting back to preponderance of evidence. In the cases that are brought before this board, who holds the burden for a preponderance of evidence? Or is it equally held between parties?
It's initially with the city. If the city issued a citation, they have the obligation to prove to the board by preponderance of the evidence that a violation occurred, and it occurred as they explained it. If there's an affirmative defense raised by the appellant, then the appellant then has the burden of proving his or her defense by preponderance of the evidence. Then you look at both and you weigh the evidence, and you said, okay, the scales tip however slightly in one favor or the other, then you render your decision based on that.
Okay.
But it depends on who's presenting the case. If it's a city with their citation, they initially have the burden of proof. If it's an affirmative defense being raised by the appellant, then they have the burden of proof.
So we have to understand that even though we have great inspectors who've done a good job and provided a preponderance of evidence in a particular case, that because that they are viewing things from public domain, have not maybe entered into the property, have not been able to ask questions, that the potential for a preponderance of evidence weighs on the plaintiff. And the staff has to understand that. Is that not true?
Well, if the city notices a potential violation from the public easement, and they check to verify, see if a permit was ever obtained for a roof or
Sure.
HVAC or something else, I think they can present their case based on the records and what's on the file with the city. And then it's up to the appellant to say, no, I do have a permit, or I did, or whatever defense they have to present that evidence. And if you are convinced that it's more likely than not that the appellant has overcome the initial evidence presented by the city, then the board has the right to rule in favor of the appellant. But it's initially the city's burden, and then if there's a defense, the appellant can raise their defense, and they must approve. They're held to the same standard, not to a higher standard, but to the same standard of a preponderance, more likely than not that it's probably happened.
So that was a complex case that we heard today. And by the way, I want to say thank you to staff. Very excellent presentation. Clear, no mumbo jumbo. I was right there with you. Good stuff. Thank you. So that was a thing that we really had to weigh and go through the whole process and understand the whole thing to get to a conclusion. But what I was really referring to is something more simple.
Okay.
Trash cans, right? Someone's not putting their trash cans in the appropriate place. Someone gets a citation for it. That's a real easy thing to weigh the preponderance of evidence between staff and the owner, right?
Right, unless the owner comes back and says, I put it out there, here's a picture of me putting it out there. Some neighbor kid pulled it off the curb and moved it someplace else.
Right. I didn't mean to bring that up. I apologize. That was kind of a close to home thing.
Okay.
I actually got a citation myself. City inspector came by, or a code officer came by, sent me a citation because trash cans were not in a proper enclosure. What he didn't realize is he was talking about my neighbor, not me. My trash cans are behind the fence, out of sight, and my neighbors, for 30 years, have been on the side of his house in plain sight of the sidewalk and everything else. So I got the citation, and I simply had to go back and state, hey, you got the wrong address. So I didn't mean to bring that up. I'm just saying that's a
Right.
real simple case, right?
Yes, because I think you could have taken a photograph of your trash cans and a photograph of your neighbor's trash cans,
Yep.
brought that in, and that would have been
Evidence.
convincing to the board. It may have been convincing to
Yeah.
the board to say, I have an affirmative defense. These are not my trash cans.
Yeah.
Yeah.
So I guess where I really just wanted to make sure that I'm in my right mind as to where we belong with the city and the law, and that is the preponderance of evidence is really a burden on both parties,
Correct.
right? Ultimately, the city presents a citation, so they have the burden. But then the plaintiff has the ability to show a preponderance of evidence that that is really not completely factual, or based on what they saw, there were extenuating circumstances that would throw that preponderance on the other side.
Correct. I mean, for example, you decided the one about the good cause today. The young lady who came in and presented some of the evidence, it appears that she was able to convince the board that I was out of town, I never received the letter, and therefore that would justify a delay filing. It appeared to justify the delay filing on the board's position, because the evidence she presented or offered to the board was that I didn't receive the notice. I went to the wrong address. I was out of town. When I came back into town, here's my ticket from being out of town. As soon as I got back into town, I not ran to the city, but I submitted my appeal that same day. And I think the board was justified in determining that based on the evidence she presented, it's more likely than not that she did not receive the notice, proper notice, and we will allow the late appeal.
Mm-hmm. Absolutely right.
Any other questions?
Yeah.
Thank
Thank you
you.
very much.
Very good.
That was good. Okay, so can we move on to the report from the secretary? Do we have a report?
Good afternoon, board members. Just a brief report, stepping in again for Secretary Frampton, Assistant Director Ashley Atkinson. I think we are going to cancel the next meeting on April 21st, so just wanted to share that with you, that we do not have any items scheduled at this moment, so you should see that official cancellation coming through soon. Otherwise, nothing to report.
Thank you very much. And now, do we have any oral communication from the audience? Or anything unscheduled communication? None? All right, so we're ready to adjourn. It's 2:06, so we are adjourning.